Hi and Assalamualaikum. Today our group will present about the case between Kesatuan Kebangsaan Pekerja-Pekerja Hotel, Bar and Restaurant Semenanjung Malaysia and Subang Jaya Hotel Development Sdn Bhd, Grand Dorset Subang Hotel. Before we start our discussion, my name is Nushaura Azrin Binti Sarizal. We will present about the introduction. According to Bethel and others, industrial relation is part of management, which is about manpower of the organization, whether machine operator, skilled worker or manager. The primary goal of industrial relation is to promote fair and stable relation between the two industrial partners, management and labor. Industrial relation and employment law involve an examination of the relation between worker and their employees within the work environment. The right and obligation of employers and employees differ depending upon whether the worker belong to a trade union or not. When none of the workers in a particular workplace have joined a trade union, relationship between the employers and the employees generally individual one, compared to the collective relationship which exists in situation on worker join a trade union. Based on the case that we choose for our group assignment, there are 3 issues within 2 articles that were discussed in the collective agreement, which are Article 10 of Salary Structure and Annual Increment, and Article 12 of Service Class. Collective agreement is an agreement of things that has been discussed during collective bargaining between the trade union of employees and the employer or employer union.
Hi, my name is Nur Adi Binti Jabar. Today, our group will present about our case study on the dispute between the Kesatuan Kebangsaan Pekerja-Pekerja Hotel, Bar dan Restoran and the Subang Jaya Hotel Development Sdn Bhd. In this case, the employee union want to renew their collective agreement from the 9th collective agreement to 10th collective agreement. From the previous meeting held by the union and the employee, both of them informed to the court that there are total of 45 articles within the 10th collective agreement. However, only 2 articles were disputed and unable to resolve. From the 2 articles that were disputed, there are 3 legal issues on it, which is the first one is salary structure, and the second one is annual increment, and the third one is service charge. So now we will move to the first disputed issue, which is salary structure. In this case, the union of employee had announced that they will achieve an additional sum of 8%. On the other hand, the employer suggested that an immediate 4.5% rise in any employee minimum pay should be given. So this led both parties to unresolved issue. So, in determining and deciding the question of wage structure and wage increase, the court has considered some factor, which is the wages is based on the company in the same region, the cost of living and financial capacity of the company to pay higher wages. So, the increase of wages will normally be awarded by the court only within the limit of the company financial capacity. So now we will move to the second issue, which is annual increment. In this case, the dispute is related to the proposed yearly increase of 5% for each band of employee in the workplace. So in this workplace, there are 5 bands as specified in the agreement. In comparison, based on what we learned in Employment Act 1955, it was not stated clearly or specifically about the annual increment. Due to this case, it does not have an act to refer, so it will depend on the court decision to award the case either to the employee or employer. So in this case, the court has award to the employee to claim their annual increment of 5% is subjected to a maximum capacity of RM100 for each band of employee.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Ahmad Aizat bin Ahmad Suhaimi, 20184414442 from class KBA 243-5A. Now, I would like to continue to the next legal issue, which is regarding to the Article 12 of Service Charge. For your information, this is the main and the most highlighted legal issue in the case study. For your information, Article 12 is about service charge. So, what is service charge? Service charge is service price paid by customer or consumer for a certain service provided by employee or workers, especially in the service sector such as hotel industry. The issues between the trade union and the employer started when the government had introduced the Minimum Wages Order Act (MWO), which stated that the minimum wages of RM900 to all employee and workers in Peninsular Malaysia. Wages system in the hotel industries is a bit different from other industry. Hotel industry practice basic wages plus service charge to become wages. For example, when an employee basic wages is RM500 plus service charge of RM1,500, then the wages of the employee become RM2,000. As you can see from the given example, the basic wages of employee is still RM500, which is below the minimum wages. The employee union state that the service charge cannot be added to the basic wages of employee just to meet the minimum requirement of basic wages. Hence, the employee union demand that the employer should top up separately using their own money to the basic wages just to meet the minimum requirement of basic wages, which is RM900. However, the court has ordered that employer is entitled to take into account the service charge in determining its employee or worker wages. This is because, according to Section 2 of Employment Act 1955, the term wages itself does not exclude the service charge.
Next, I will present about the recommendation. We would like to recommend to our government to create a new law or act to require mandatory and annual increment to the employees. This is because most of the employees did not want to increase their annual increment of the employees. Many employers did not want to rise their annual increment of the employees' wages and will do so only when the government had announced the minimum wages of the employees. I feel that is a weakness of our Employment Act because it does not state that an employer must increase their employees' wages annually based on the performance of the state of staff and the company, said Datuk Abdul Halim, also the President of Malaysian Trade Union Congress (MTUC). It is important to give employees an annual increment because it shows that the employer had valued them and their contribution to the company. An annual increment can boost and increase employer satisfaction and encourage their hard work. Besides that, we will suggest to the employer give an annual increment to the employees who had performed in their job and to the employees had worked more than 5 years. Next, I will present about the conclusion. In conclusion, if no employee has entered a labor union at a specific place or workplace, there is typically an individual relationship between the workers and the employer, contrast with a contractual relationship that is existing in case where employees have joined a syndicate. Collective agreement is an agreement of things that has been discussed during collective bargaining between the trade union of employees and the employers or employer union. Conclude, between a trade union of workmen on one hand and a trade union of employer or employer on the one hand during the collective bargaining process. It is important for employees to join a trade union because it will help the employees to bargain with employer in so many aspects. In this case, there are 3 legal issues that need to be solved, as both the employee union and employer could not achieve a mutual agreement. Issue has regarding the salary structure and service charge in the hotel industry. We must know that in the hotel industry, the salary structure is different from other industries. Hotel industry use wages based on the service performed and employee and their performance to grade salary structure. When compared to normal industry, they usually use basic clean wages, thus it is less of an issue because it is quiet, fixed and stable compared to service rate. The case of Kesatuan Pekerja-Pekerja Hotel, Bar and Restaurant Semenanjung Malaysia and Subang Jaya Development Sdn Bhd Grand Dorset Subang Hotel really made us understand more about the real problem and issue that are very common in the industry has detailed. It highlights issues that had been common in the industrial court and even in the High Court of Appeal. We as student Part 5 were merely knowing anything about the issue until we learned and made this assignment. We think that this assignment is extremely helpful and very effective in increasing the knowledge and information of students regarding the industrial relation HRM 659. Thank you.